When I have a client that comes to me who has been accused of domestic violence and they swear to me that they haven't done anything, I start looking for the evidence. In one case, I found out that my client was in an entirely separate state, more than 45 minutes away when the alleged incident happened. In another case, they had in-home cameras, a nanny cam specifically, that caught the alleged incident on camera, and it was not at all like the accuser described. And in a third case, we found out that the phone abuse that was being alleged was actually a burner phone being done by the accuser's sister. You gotta look for the evidence, because if someone is making up these allegations, and I hope that doesn't happen often, but when it does, there's often a trail of falsified evidence, and so you've really gotta start looking out for that. The other thing is you gotta think strategically. If you can't find evidence that this is a false accusation, we're likely going to sit down with you and have a serious conversation about whether it makes sense to just consent to a protective order without any finding whatsoever, so that you can move forward. Sometimes there can even be a strategic advantage in this. In one case where I had a gentleman who was accused of domestic violence, we consented to a protective order, but only with 50-50 custody moving forward. In another one, we consented, but because it was my client's house, the accuser actually had to leave the house, even though my client swears nothing happened. It was his house, and with the protective order, he got the house to him. So strategy can take a variety of different opportunities, and you want to sit down with an attorney who knows what they're doing.